Thank you, Mr. Chairman. Judge Garland, welcome.
Thank you, Senator.
Congratulations on your nomination.
Thank you.
In 2+ decades on the court, you have built a reputation for integrity and for setting aside partisan interests and following the law. The job to which you have been appointed is a very different job. And as I look back over the 8 years of the Obama-Biden Justice Department, in my view, the most problematic aspect of that tenure was that the Department of Justice was politicized and weaponized in a way that was directly contrary to over a century of tradition of the Department of Justice of being apolitical and not a partisan tool to target your opponents. So it is very much my hope, if you're confirmed as Attorney General, that you will bring that reputation for integrity to the Department of Justice and demonstrate a willingness to stand up for what will be inevitable political pressure to once again politicize the Department of Justice and use it as a tool to attack the political opponents of the current administration. Eric Holder, before he was nominated as Attorney General, had likewise built a reputation as being relatively nonpartisan and a prosecutor with integrity. And unfortunately, his tenure as Attorney General did enormous damage to that reputation. As was previously discussed, Eric Holder described his role as Attorney General as being the wingman for President Obama. Am I right in assuming you do not view your role as Attorney General as being Joe Biden's wingman?
Yeah, Senator, as I said, I don't want to comment on any individual's conduct as any of my predecessors or FBI directors' conduct in any way. But I can assure you I do not regard myself as anything other than the lawyer for the people of the United States. And I am not the president's lawyer. I am the United States lawyer. And I will do everything in my power, which I believe is considerable, to fend off any effort by anyone to make prosecutions or investigations partisan or political in any way. My job is to protect the Department of Justice and its employees in going about their job and doing the right thing according to the facts and the law.
Under the Obama administration, the IRS targeted the political opponents of the president. It targeted conservatives for their speech. It targeted pro-Israel groups. It targeted Tea Party groups. It targeted individuals perceived to be on the opposite political side as the administration. Will you commit as Attorney General that you will not allow the Department of Justice to be used to target those who are perceived as political opponents because they are political opponents?
Absolutely. I will not.
Also under the Obama administration, Operation Choke Point was used to pressure lawful organizations, lawful institutions, for example, that sell firearms, to constrain their lawful activity and to use regulatory authority to abuse and force them to comply with the administration's stated policies. Do you believe it's appropriate for the administration to use regulatory pressure to force lawful behavior to stop?
Senator, I'm not aware of the specific that you're giving, and I expect you don't expect that I would have been aware of it. But of course, I do not believe, as a general matter, that regulations should be used to stop people from doing what they're lawfully entitled to do, unless the regulation is pursuant to a statute, obviously, in which Congress is given authority to change the rules.
As you also know, Attorney General Eric Holder was held in contempt of Congress, criminal contempt of Congress. That was a bipartisan vote. 18 Democrats voted to hold Attorney General Holder in contempt. They did so because he refused to produce documents to Congress for Congress's investigation of the Fast and Furious scandal, a major scandal that resulted in the death of 2 federal law enforcement officers. You've previously committed to senators on this panel that under your leadership, the Department of Justice will comply to the extent possible with requests from this committee. And I want to, in the course of this question, associate myself with Senator Whitehouse's comments and questions. He and I disagree on a great many issues, but on this particular issue, we are emphatically in agreement that senators from this committee should get answers, should get candid answers, should get substantive answers, should get real answers from the Department of Justice, regardless of the party of the senator asking that question, that is a level of oversight that the American people have a right to expect. Do you agree with that?
I do think that this is a level of oversight the American people have a right to expect. I want the department, if I'm confirmed, to be responsive to the extent it's possible with respect to the Justice Department's appropriate equities, to be responsive to the requests for information.
So you've had, previously you said you've read the executive summary of the Horowitz report. What was your reaction to the Horowitz report?
Well, I thought, as Mr. Horowitz explained, and I believe Director Wray agreed, there were problems with respect to the applications for several FISAs, that those were not consistent with the internal regulations of the department, and that those problems had to be corrected. I think deeply that we have to be careful about how we use FISA, and that's the reason we have pretty strict regulations internally and policies, and we need to find out why they aren't followed and to be sure that they are followed. I understand that was the purpose of his report and his recommendations to Director Wray.
So you described the report as saying there were problems. That's a fairly anodyne way of characterizing it, given the multiple material misstatements the Horowitz report details, including Mr. Klein-Smith's fabrication of evidence and lying to a court, which he's now pleaded guilty to. I think that was yet another example of the deep politicization of the Department of Justice, culminating in a meeting with the acting Attorney General, President Obama, Vice President Biden in the Oval Office concerning the targeting of their political opponent. Will you commit to this committee that under your leadership, the Department of Justice will not target the political opponents of this administration, and there will be real scrutiny? What that report outlines, among other things, is weaponizing Oppo research from the Hillary Clinton campaign and launching a criminal investigation based on that. Will you commit that that conduct will not be acceptable under any Department of Justice you're leading?
So absolutely, Senator, but without trying to comment specifically on that matter, it's totally inappropriate for the department to target any individual because of their politics or their position in a campaign. The only basis for targeting has to be evidence of the risk of foreign intelligence problem or of a criminal problem. And that is a nonpartisan issue. That is a question of objective facts and law, and it can never be an effort to help one party or another party. In investigations and prosecutions, there is no party. The department is an independent, nonpartisan actor, and that's my job to ensure that that's the case.
Thank you.
Thanks, Senator Cruz. We now understand.
Thank you, Mr. Chairman. Judge Garland, I want to go back to the topic of protecting the Department of Justice from political influence and being weaponized politically. A number of Senate Democrats at this hearing have used the opportunity to cast aspersions to the job Bill Barr did as Attorney General. I think those aspersions are false. I think he showed enormous courage in fighting to defend the rule of law. But Bill Barr, when explicitly asked about whether he would terminate Robert Mueller at his confirmation hearing, the same situation you find yourself, he said he would not terminate him absent, quote, good cause. Are you willing to meet the same standard of integrity that Bill Barr demonstrated? And will you make that same commitment to this committee that you will not terminate Mr. Durham absent good cause.
What I've said to committee and just what is that I need to get information about this investigation, which I do not have here. I understand that a decision has been made to keep him in place, and I have absolutely no reason to doubt that that was the right decision and that he should be kept in place. But I can't go any further without learning the facts of the investigation and what the status is.
So, Judge Garland, with all due respect, and I recognize you've been a judge for 23, 24 years, judicial nominees sit in that chair and decline to answer just about every question senators pose them, as saying, well, as a judge, I can't commit how I would rule on any given case, and that's appropriate. You're not nominated to be a judge in this position. You are nominated to an executive position, and you're a constitutional scholar. You understand fully well the difference between attorney general versus an Article III judge. Bill Barr didn't know the details of the Mueller investigation at the time, but he knew that Bob Mueller was investigating President Trump, that it was highly politically sensitive. And so to show his integrity and commitment to being nonpartisan, he said he wouldn't terminate Mueller absent good cause. You have the opportunity to do the same thing. The investigation into Durham is highly political. It potentially implicates Joe Biden and Barack Obama. And I just want to be clear, you're refusing to give that same commitment. You want to keep the options open to terminate the investigation.
Look, I'm not refusing to give that commitment because I am a judge. I'm telling you what I think an attorney general ought to do, which is to look at the facts before making a decision. I'm also telling you that I will never make a decision in the department based on politics or on partisanship. So whatever decision I were to make, it would not be based on that. And all I can ask you to do is trust me based on a record of my 24 years as a judge, my entire career before that as a prosecutor, and my life before that. That's my record of integrity, and that's what you have before you.
So a similar line of questions that you were asked concerned the Google antitrust investigation. And Google, big tech as a whole, contributed over $15 million to the Joe Biden campaign. They're enormously important Democratic donors. There will be enormous political pressure to abandon that case against Google. Can you give this committee assurances that you can stand up to that political pressure just because Democratic fundraisers want to be lenient on Google, that the Department of Justice will not give in to that pressure?
So, Senator Cruz, I'm old enough to remember when there was a political effort to end the case in the antitrust case in the Justice Department against ITT, which gives you an idea of how old this is, that there is no ITT anymore, the International Telephone and Telegraph Company. This, if I'm not wrong, this was one of the paragraphs in the indictment, the proposed indictment, impeachment of President Nixon, I think, but it was around the same time. And it had to do with a partisan effort to influence the Justice Department and the Antitrust Division. I grew up knowing that this is not something that is permissible for the Justice Department to do. And my whole life has been in looking at Ed Levy and Watergate, post-Watergate attorneys general who stood up to that kind of stuff. And I can assure you that I don't care what kind of donor talks to me about what of anything. I don't expect to talk to any donors. I have no conflicts. I don't own any Google stock, and I will do whatever is the right thing, and I don't own any stock, or I won't once if I'm...
Let me ask two very quick questions because my time is expiring.
Yeah.
Number one, you voted to rehear the Heller case, or actually the Parker case, en banc.
I did.
I argued the Parker case in the D.C. Circuit. As Attorney General, will the Department of Justice argue for the Supreme Court to overturn Heller versus District of Columbia?
Look, the department, makes all kinds of judgments like that. I can't promise, but I find it hard to believe that the department could think that there was any possibility of overturning the Heller case.
Okay, and then the final one, with the chairman's indulgence, because I'm at the end of my time.
Yeah.
9 senators wrote a letter to Chairman Durbin asking this committee to investigate Governor Andrew Cuomo's policies concerning COVID and sending COVID-positive individuals into nursing homes. A senior aide of his admitted to a cover-up to hide information from the Department of Justice. You've committed to a number of investigations here at this hearing today. Will you commit to investigating the extent to which the government of New York broke laws or covered up their policies concerning COVID-positive patients in nursing homes?
With all of these investigations, the Justice Department is open to evidence of fraud, false statements, violations of the law. They normally begin in the appropriate way in the relevant U.S. Attorney's Office. And that is the way that something like this, without commenting on this in particular, because I don't know the facts.
But in this instance, the acting U.S. attorney is the mother-in-law of the senior official in the Cuomo administration that admitted to the cover-up. Will you at least commit to not having the investigation done by a person with a conflict of interest?
Of course. I don't know any of the facts, but I can guarantee you that somebody with a conflict of interest will not be the person running an investigation of any kind.
Thank you.
Since it has appeared, reappeared, and then appeared again, this question about the Durham special counsel.
When President Biden nominated Merrick Garland, I was originally gratified. There were a great many choices President Biden could have made from individuals who have long records as partisan warriors, and Merrick Garland is not one of them. Judge Garland has spent over 2 decades on the Federal Court of Appeals. He's built a reputation for integrity. He has built a reputation for not being overly partisan. And so I was hopeful that when Judge Garland came before this committee, that he would indicate a commitment to the rule of law and a commitment to standing up to the hard politicization and weaponization of the Justice Department that we saw during the 8 years of the Obama-Biden administration. I have to say, Judge Garland's testimony before this committee and his subsequent answers to the questions for the record left me deeply, deeply disappointed. On question after question after question, Judge Garland refused to answer virtually anything. When asked by multiple senators about the Durham investigation, he refused to answer whether he would fire John Durham. He refused to answer whether he would meet the bar standard. He simply said he didn't know anything about the Durham investigation. Now, of course, when Bill Barr had been nominated to be Attorney General, he didn't know anything about the Mueller investigation either, other than he knew that it was an investigation into the President of the United States in a highly politicized context. And knowing that, Bill Barr made a commitment to this committee that he would not fire Bob Mueller absent good cause. There's nothing to prevent Judge Garland from making the same commitment, except if he wanted to have the flexibility to fire him, Mr. Durham, for something other than good cause. And yet repeatedly, over and over and over again, he wouldn't answer that question. He also refused to answer the question whether the Department of Justice will continue prosecuting people who cross the border illegally. Never mind that the Constitution obliges the President and all of the executive branch to take care that the laws be faithfully executed. Judge Garland wouldn't tell this committee that he would faithfully execute the laws. He refused to answer whether the repeated violent assaults on the federal courthouse in Portland, including multiple violent attacks on federal law enforcement officers, constituted terrorism. Indeed, to the extent he proffered an answer, he suggested that it did not because those attacks occurred at night, something that I am confident is a novel definition of terrorism, since I am not aware of any legal definition, in statute or otherwise, that defines terrorism as activity that only occurs when the sun is in the sky rather than at nighttime. He refused to answer to this committee whether or not the Department of Justice would urge that the Heller decision be overturned. The Heller decision, of course, is the landmark decision upholding the Second Amendment right to keep and bear arms. He refused to answer that question. He refused to answer whether he would reinstate Operation Choke Point, which abused federal regulatory authority to target politically disfavored individuals and companies. Subsequent to his hearing, I and many other senators submitted a series of questions for the record for Judge Garland. I didn't think it was possible for answers to be less forthcoming in writing than they were in person, and yet the answers to the QFRs are indeed less forthcoming. In response to a whole series of questions about the Durham investigation, his response was, as I testified at the hearing, I do not know anything about the Durham investigation except what I've read in the press. His response, when asked about the meeting on January 5th, 2017 in the Oval Office, where President Obama and Vice President Biden directed the Department of Justice and the FBI to target the incoming Trump administration and to target the incoming National Security Advisor Michael Flynn, a meeting that is discussed at length in the Horowitz report and the executive summary, which Judge Garland said he has read. His response was, I do not know the facts of the situation you described. As I stated at the hearing, as a nominee, I should not comment about Justice Department officials' prior decisions or hypothetical situations. Mr. Chairman, I want you to pause to think about the two things he says he won't comment about. Anything a prior Department of Justice has done, he won't comment on that, and he won't comment on hypothetical situations. I'm not sure what remains if you won't comment about actual situations or hypothetical situations. What remains is essentially a null set. He refused to tell this committee whether he would reinstate the politicized decision-making of the Eric Holder and Loretta Lynch Departments of Justice, and he refused to entertain any hypotheticals whatsoever. When asked about Operation Choke Point, he said he wasn't familiar with it. Questions for the record asked, now that he's had an opportunity to familiarize himself with it, what are his views? His answers were, since the confirmation hearing, I have not studied these issues any further and have no additional comments. On the question of the Second Amendment and whether the Department of Justice would seek to overturn the Heller decision and effectively erase the Second Amendment from the Bill of Rights, what little commentary Judge Garland would provide in his written answers only raises cause for concern. He said in particular, I believe as a general matter that we should be very careful that people who are entitled to guns get the background check that allows them to have them, and that for those who are not entitled and who are concerned, who we are concerned about because they are threats, because they are felons, or for whatever reason are barred by the law, that there is an opportunity to determine that they are not permitted to have a gun. He makes no commitment to protect the Second Amendment. On the question of whether the Department of Justice would enforce immigration laws and in particular continue to prosecute those across the border illegally, here's Judge Garland's answer. As I said to Senator Hawley, I just haven't thought about that question. The President has made clear that we're a country of borders and with concern about national security. I don't know of a proposal to decriminalize, but still make it unlawful to enter. Since the hearing, I've not had time to think further about the question. So since the hearing, Judge Garland has not had time to think further about enforcing our immigration laws. This pattern is reminiscent of Sergeant Schultz out of Hogan's Heroes. What Judge Garland has told this committee is, I see nothing, I hear nothing, I know nothing. At times, when convenient, his answers to the QFRs resort to the judicial canons of ethics to say, as a sitting judge, he is prohibited from commenting on any particular issue, but I would note at the hearing, he was quite willing to comment about prosecutorial priorities when asked by Democratic senators to make commitments in that regard. Not only did he refuse to answer questions at the hearing, not only did he refuse to answer questions for the record, but Judge Garland is also one of the few Biden cabinet nominees refusing to take in-person meetings with senators, categorically refusing to take them. Multiple other Biden nominees are taking them. And so I would note to my colleagues on this committee, both sides of the aisle expressed considerable frustration with the Department of Justice that resist efforts of the Senate to engage in oversight. Judge Garland's conduct before this committee and his confirmation gives no reason for comfort in that regard. If he's not willing to answer questions now, before he's confirmed, the likelihood of his being willing to answer questions after he was confirmed is only smaller. On the response to the questions for the record, it is difficult for a lawyer to draft answers to this committee that are more of a jump in the lake to the Judiciary Committee than these answers are. They reflect a view that's saying, I don't know, on any policy issue is acceptable to be confirmed as Attorney General. I very much hope that my initial assessment of Judge Garland proves right. From the vote on this committee, it appears likely that his nomination will move forward and that he will be confirmed. But for the Republican colleagues who have expressed concerns about another Holder or another Lynch Department of Justice, I would note that both Eric Holder and Loretta Lynch were much more forthcoming before this committee than Judge Garland. He has not even met the standard, the Holder or Lynch standard. And for this committee, the precedent this committee is setting is that a nominee for Attorney General can sit before this committee and essentially refuse to answer all questions. Say, I don't know, I can't tell you, I don't know. And whichever party is in the majority will vote to confirm that nominee nonetheless. That's a precedent I predict will come back to haunt this committee. And I hope that the votes to confirm him will not prove a mistake. On the question of whether the Department of Justice would enforce immigration laws and in particular continue to prosecute those across the border illegally, here's Judge Garland's answer. As I said to Senator Hawley, I just haven't thought about that question. The President has made clear that we're a country of borders and with concern about national security. I don't know of a proposal to decriminalize, but still make it unlawful to enter. Since the hearing, I've not had time to think further about the question. So since the hearing, Judge Garland has not had time to think further about enforcing our immigration laws. This pattern is reminiscent of Sergeant Schultz out of Hogan's Heroes. What Judge Garland has told this committee is, I see nothing, I hear nothing, I know nothing. At times, when convenient, his answers to the QFRs resort to the judicial canons of ethics to say, as a sitting judge, he is prohibited from commenting on any particular issue, but I would note at the hearing, he was quite willing to comment about prosecutorial priorities when asked by Democratic senators to make commitments in that regard. Not only did he refuse to answer questions at the hearing, not only did he refuse to answer questions for the record, but Judge Garland is also one of the few Biden cabinet nominees refusing to take in-person meetings with senators, categorically refusing to take them. Multiple other Biden nominees are taking them. And so I would note to my colleagues on this committee, both sides of the aisle expressed considerable frustration with the Department of Justice that resist efforts of the Senate to engage in oversight. Judge Garland's conduct before this committee and his confirmation gives no reason for comfort in that regard. If he's not willing to answer questions now, before he's confirmed, the likelihood of his being willing to answer questions after he was confirmed is only smaller. On the response to the questions for the record, it is difficult for a lawyer to draft answers to this committee that are more of a jump in the lake to the Judiciary Committee than these answers are. They reflect a view that's saying, I don't know, on any policy issue is acceptable to be confirmed as Attorney General. I very much hope that my initial assessment of Judge Garland proves right. From the vote on this committee, it appears likely that his nomination will move forward and that he will be confirmed. But for the Republican colleagues who have expressed concerns about another Holder or another Lynch Department of Justice, I would note that both Eric Holder and Loretta Lynch were much more forthcoming before this committee than Judge Garland. He has not even met the standard, the Holder or Lynch standard. And for this committee, the precedent this committee is setting is that a nominee for Attorney General can sit before this committee and essentially refuse to answer all questions. Say, I don't know, I can't tell you, I don't know. And whichever party is in the majority will vote to confirm that nominee nonetheless. That's a precedent I predict will come back to haunt this committee. And I hope that the votes to confirm him will not prove a mistake. Thank you, Mr. Chairman. For 8 years under Barack Obama, the Department of Justice was politicized and weaponized. When you came before this committee in your confirmation hearing, you promised things would be different. I asked you specifically, quote, will you commit to this committee that under your leadership, the Department of Justice will not target the political opponents of this administration? Here was your answer, quote, absolutely. It's totally inappropriate for the department to target any individual because of their politics or their position in a campaign. That was your promise just a few months ago. I'm sorry to say you have broken that promise. There is a difference between law and politics. And General Garland, you know the difference between law and politics. Law is based on facts. It is impartial. It is not used as a tool of political retribution. This memo was not law. This memo was politics. On Wednesday, September 29th, the National School Board Association wrote a letter to the President asking the President to use the Department of Justice to target parents that were upset at critical race theory, that were upset at mask mandates in schools, to target them as domestic terrorists. On the face of the letter was in repeated consultation with the White House, in explicit political consultation with the White House. That was on Wednesday, September 29th. 5 days later, on Monday, so right after the weekend, boom, you pop out a memo, giving them exactly what they want. Now, by the way, I understand that. In politics, that happens all the time. An important special interest wants something. Sir, yes, sir. We're going to listen to them. Let me ask you something, General Garland. In the letter, which you told the House of Representatives was the basis for this abusive memo targeting parents, how many incidents are cited in that memo?
I have to look back through the memo. I can't count it.
You don't know. How many of them were violent?
Again, the general report.
How many of them were violent? Do you know?
I don't know.
You don't know. And there's a reason you don't know. Because you didn't care, and nobody in your office cared to find out. I did a quick count just sitting here. During this hearing, I counted 20 incidents cited. Of the 20, 15 on their face are nonviolent. They involve things like insults. They involve a Nazi salute. That's one of the examples. My God, a parent did a Nazi salute at a school board because he thought the policies were oppressive. General Garland is doing a Nazi salute at an elected official. Is that protected by the First Amendment?
Yes, it is.
Okay. 15 of the 20 on the face of it are not violent. They're not threats of violence. They're parents who are unhappy. Yet, miraculously, when you write a memo, the opening line of your memo, in recent months, there has been a disturbing spike in harassment, intimidation, and threats of violence. You know what? You didn't look, and nobody on your staff looked. Did you even look up the 20 instances?
As I testified, the decision to send a memo is for an assessment.
Did you look up the 20 instances?
I did not read.
Did anyone on your staff look them up?
I don't know the answer, but it's not
but of
the
course
memo.
you don't. In general, there's a reason. Look, you started your career as a law clerk to Justice Brennan. You've had many law clerks during the year, during your time as a judge. I was a clerk to Chief Justice Rehnquist. I'll tell you what, if I drafted an opinion for the Chief Justice and walked in and it said, there's a disturbing pattern of violence, well, Ted, how do you know that? Well, I got an amicus brief here who claims it. You would fire a law clerk who did that. You're the Attorney General of the United States. This was not a tweet you sent. This is a memo to the Federal Bureau of Investigations saying, go investigate parents as domestic terrorists.
That is not what the memo says at all. It does not.
Is it what the letter says?
That is not what.
Is it what the letter says?
I don't care what the letter says.
You don't care. You said it was the basis of your memo. You testified under oath before the House of Representatives. The letter was the basis of your memo. Now you don't care about the letter?
The letter and public reports of violence and threats of violence. My memo says nothing about domestic terrorism, says nothing about parents committing any such things. My memo is an attempt to get an assessment of whether there is a problem out there that the federal government needs to resolve.
The letter on its face says the actions of the parents could be the equivalent to a form of domestic terrorism.
And that is wrong.
And asks the president to use the Patriot Act in regards to domestic terrorism
and
directed at parents.
And
this was the basis of your memo.
My memo.
The Department of Justice, when you're directing the FBI to engage in law enforcement, you're not behaving as a political operative because a political ally of the president says, hey, go attack these parents because we don't like what they're saying. Department of Justice, you did no independent research on what was happening, did you?
The memo has nothing to do with partisan.
Did you do independent research?
The memo has.
Did you do independent research?
The memo has nothing to do.
Okay, you're
with
not answering that
politics.
question. You've testified you know nothing about the violent sexual assault that happened in Loudoun County, even though it's one of the bases in this letter.
I read about it since then.
Okay. You told the House last week you knew nothing about it.
Not know at the time, no.
Okay. This week, the court concluded that a 14-year-old girl was violently raped by a boy wearing a skirt in the girls' restroom. The school district covered it up, released the boy, sent him to another school where he violently raped another girl. The father, who Mr. Hawley just showed you, was the father of the first girl. He was understandably, do you understand why a parent would be upset when your daughter is raped at school, the school board covers it up, and then lies to you and claims there have been no assaults, we have no instances of assaults in our bathroom, and that was a flat-out lie, as the court concluded this week. Do you understand why the parent would be upset?
Absolutely, and any expressions of upset are completely protected by the First Amendment.
Except you just called him a domestic terrorist.
I never called him that. That's not correct.
This letter calls him a domestic terrorist. You based a direction to the FBI, an official direction from the Attorney General, on this letter, and I'll tell you what, the NSBA is so embarrassed of this letter, they've apologized for it and retracted it, but you don't apparently have the same willingness to apologize and retract what you did.
Senator Cruz.
We talked just a minute ago about the difference between law and politics. We heard some impassioned political speeches, but also a question that just was asked by my friend from New Jersey. Is there anything in this memo to tell a parent that they're being targeted for harassment and intimidation? I would note that the letter from the school boards cited 20 instances, 15 of which were nonviolent. The letter from the school board described them as domestic terrorism. Within days, the Department of Justice snapped to the commands of the special interest and issued a memo, a directive to the Department of Justice and a directive to the FBI. This is, again, where law matters. The opening sentence describes a disturbing spike in harassment, intimidation, and threats of violence. Now, you spent a long time as a judge when you have 3 things listed. Am I correct that anyone interpreting that, reading it, would conclude that harassment and intimidation are something different than threats of violence, given that you listed each of the three out separately. Is that consistent with the canons of construction?
The memorandum is addressed to professional prosecutors.
I asked you a question, not who it was addressed to.
Senator, at least let him respond.
No, not when he answers a non sequitur. If
He
wants
may
to
respond.
answer okay, you're taking my time now. This is not coming out of my time.
Listen,
when I ask a question,
we've given you more time than any other senator.
Mr. Chairman,
Now listen,
when I ask
all I'm
a
asking
question,
is allow him to respond.
Mr. Chairman, when I ask a question, he can answer the question, but he's proceeding to ask a total non sequitur. I asked about the canons of construction on the board.
Please let him respond.
I'll ask the question again. The opening line of the memo specifies harassment, intimidation, and threats of violence. Is it correct under the ordinary canons of construction that a legal reader would understand that harassment and intimidation means something different from threats of violence? Is that correct?
A legal reader would know Virginia versus Black, the Supreme Court definition of intimidation, and a legal reader would know 18 U.S.C. 2261A, the definition of harassment.
And would a parent?
This was not addressed to parents.
But you know, parents read it. You're the Attorney General of the United States. You said you can't think of anything harassing. You directed the G-men, the FBI, to go after parents. All right, let's move on to a different topic. We've sadly seen that you are willing to use the enforcement power of the Department of Justice to target those who have political views different than you, even if it's a mom at a PTA meeting. Let's try the other side. Are you willing to enforce the law fairly against people who are political allies of the president? At a Senate hearing in May, Dr. Fauci said, quote, "The NIH has not ever and does not now fund gain-of-function research in the Wuhan Institute of Virology." That was under oath, under testimony. On October 20th, the NIH principal deputy director, in writing, directly contradicted it. Those two statements cannot be true. As you know, Section 1001 of Title 18 makes it a federal crime to knowingly make false statements to Congress. Is the Department of Justice investigating Dr. Fauci for lying to Congress, and will you appoint a special prosecutor to do so?
I'm going to say again, the memorandum that I issued is not partisan in any way. It has nothing to do with what I agree with or I don't agree with. I don't care whether the threats of violence come from the left or the right.
Could you answer the question I asked?
The second question, we don't comment on criminal investigations or other investigations.
Well, amazingly, when it's the political enemies of the administration, you comment loudly in a memo. Let me ask one other question.
You're not asking.
President Biden recently said in a national town hall that police officers who decline to get vaccinated should be fired. Do you agree with President Biden on that?
I think all police officers. Look, I stood on the stage at the mall where the 700 and some police officers died this year were commemorated.
Let me try again. Do you agree with the president? It's a yes or no. You've asked questions as a judge. You know how to get a yes or no. Do you agree with the president? Yes or no?
A large percentage of the law officers who died this year died from COVID-19.
Do you agree with President Biden that police officers who decline to get vaccinated should be fired? Yes or no?
And if they had been vaccinated, they wouldn't have died.
So is that a yes? You do agree with the president?
Police officer.
In Chicago, a third of the police officers did not file their vaccination status. Do you think Chicago should fire a third of its police officers when murder rates and crime rates are skyrocketing?
This is a determination that the city of Chicago will have to make.
So do you agree with the president? The president said yes. Do you agree with him? You are the chief law enforcement officer of the United States. Do you agree with Joe Biden saying fire police officers despite skyrocketing crime rates?
That is a question that is one of state law there and will have to be decided by the state.
You have no view on whether we should fire
Senator,
cops?
your time has expired.
Well, you used 2 minutes.
No, I certainly did not. Senator Blumenthal.
Thanks, Mr.